Good evening. It's right at 6 o'clock, and it's time to start our evening meeting. And welcome to those that are here in the audience. And this is our portion of the agenda where we do public hearings. And we will start with agenda item under Human Rights, number 27.
Item 27 is proposed ordinance amending Chapter 70 of the Pinellas County Code related to wage theft and recovery. The public hearing was properly advertised. Affidavit of publication has been received for filing. No correspondence has been received. The matter is properly before the board to be heard.
Okay. I don't have any cards. Paul, do you want to still come up and go over basically what the changes being proposed are? And you are?
Madam Chair, thank you. Good evening, Commissioners.
Evening.
For the record, my name is Paul Valenti, and I have the pleasure of serving in the county's Human Rights Officer and Director of Human Rights. The proposed amendments before you this evening are intended in broad measure to do three things. One, to incentivize mediations to wage theft disputes. Some of the information we provided you by way of background information suggests that when there's a recovery of unpaid wages, most often it's through the mediation process that the program offers. So the proposals before you seek to further incentivize those efforts. It seeks to enhance enforceability of some of the orders that are made by the special magistrates that hear the wage theft disputes, should they not be able to be mediated. And then it expands the coverage against retaliation and enhances the protections for retaliation. The item, as it appears on the agenda, also reads that one of the things that the proposed amendments would do is allow for enforcement within the city of St. Petersburg, not automatically on its face. It'll certainly make it more conducive to that happening, but not by operation of the amendments before you will that automatically happen. And I think it's important to note that. And I apologize for our role in the way that that's worded. It'll certainly allow for us to have conversations with the city to take over those operations. They'd still need actually to repeal their ordinance for our ability to actually enforce in St. Pete. But we believe the amendments that are before you tonight should help to incentivize them to do so. So I could go through what the suggestions are, but I don't, if the board has read the supporting materials, I don't certainly want to consume its time knowing the busy agenda you all have. I'll do whatever is the board's pleasure, Madam Chair.
Okay. Commissioner Welch.
Thank you, Madam Chair. Excellent job on this, and you've covered the major points. You mentioned that you have a provision for retaliation
Yes.
in there as well, and a repeat offender provision, I think, is also very powerful.
Well, Commissioner, funny you mentioned that. I hate to interrupt.
Okay.
One of the things we were looking for is ways to get further compliance and enforceability of orders from the magistrate, as I just discussed. The specific provision that staff had preliminarily suggested by way of seeing additional, basically civil penalties for employers for repeat violations of the ordinance. After a lot of deliberation and consideration and back and forth with the county attorney's office, at present we're actually suggesting that that not be included. And the reason, Commissioner, is that, well, several-fold. Most importantly being, though, that there's a belief that there's not much by way of statutory support to allow the county to do that, which in turn would maybe engender a challenge to the ordinance, and then the balancing of having the ordinance in place and seeing the kind of recoveries we've had versus potentially jeopardizing the ordinance through judicial challenge didn't merit the inclusion of those provisions.
Now, it's in the red line version that we have, though.
It is. This was a conversation that we landed upon quite candidly today in conversations I've had with my liaisons at the county attorney's office. I do apologize for that. It was a continuing a conversation, but on balance, the suggestion was that it doesn't, the concern that having that provision would engender such challenges which might jeopardize the ordinance overall.
Okay, so what is coming out, the whole
So,
section
well,
6?
So Commissioner, what would be coming out is section 7308A6 that specifically talks, that's on page 8 of the markup version or page 7 of the clean version, and that's the portion that reads, if you'll bear with me, and I'll be reading from the marked up red line version. commissioners, but that's the portion that reads at subsection 6, 2/3 of the way through the bottom. If a wage theft order was issued against an employer with 3 years, it talks about a 20%, basically civil penalty, then a 40% for a third offense, and then a 60% for a fourth offense. That's the provision through conversation and discussion with the county attorney's office that's now, it's suggested not be included in the proposed amendments.
And that's precisely the section I highlighted and loved.
Oh.
Unfortunately.
Well, that is staff suggestion. You are the policymakers.
Are there any other changes in the ordinance before us that are different from what we have in the red line version?
No. I want to make sure I'm
This
understanding your
section
question.
6, for example,
Yes.
is in our version.
It
You're
is.
saying it's not what you're recommending.
It's not the current recommendation. That's
So
correct.
do we have the latest, is what I'm asking?
You do, and it was provided me by the county attorney's office, but that's the only substantive proposed change that we're now not recommending.
Okay.
If that makes sense, Commissioner.
Thanks.
And seeing as you've asked, I'll take a look at it. Commissioner?
Sir.
Madam Chair, if I may?
Yes.
So are you saying the county attorney needs to do more research, or they just think that's something we can't include?
If I could speak to the
Yes, ma'am.
question. This was an issue that we did flag a little bit later after the drafting of this ordinance. I know that Mr. Valente and his staff, many of the very successful programs that they run on behalf of the county that you get information about, they are able to do by virtue of federal laws that are in place, for instance, in the housing discrimination area. This ordinance before you is an ordinance that you would be adopting under your general authority to basically adopt and enforce ordinances as provided by the state of Florida. So we don't have that extra layer of added penalties that either the state or federal government has provided. And that is the concern, that we don't want to include something that could at least potentially lead to a challenge to the ordinance. So I do think that what we would like to do is exclude that now, and then do some more research as to whether we could include this or at least some kind of alternate form of a heightened penalty that would comport with state law. So at this time, we are recommending that one paragraph be removed in the ordinance before you for consideration this evening.
Okay. And Madam Chair, my last question is what are the material differences between our ordinance and state?
Really, Commissioner, none. We actually defined an employer a little more broadly to cover more employees engaged in work. The only two other issues that were throughout the conversations with the city of St. Pete that were of importance to them, at least as articulated, was one, that they had a provision in their ordinance which required an employer, upon the hiring of an employee, to give notice as to who the legal employer is. And I think we've covered this before. People actually, believe it or not, a lot of times people don't know who their actual legal employer is. They might know it by a trade name or a DBA, but they don't know the actual legal entity for whom they work. The second was that they wanted, they have in their ordinance a notice provision and a posting provision where the employer would be required to post information about the wage theft ordinance. In these amendments we never had it in the original ordinance, Commissioner, and we're not suggesting it in the proposed amendments. And the reason is, quite candidly, we don't have the resources to go out into the field and check compliance for whether those postings are in place. And even though the city purported that it's in their ordinance and it's something that they've had in conversations with us, they never actually enforced it themselves. We don't have the resources for it. They never enforced it themselves. And therefore, we didn't make the recommendation to include it in the amendments before you.
Okay, when it comes back to us, I would like us to talk about that a little bit more.
Okay.
So I think having it in there still strengthens it. And last, I would just want to give kudos. In our notes, it says $300,000 has been recovered in the last 3 years, and I think that's significant. So,
And I believe it's about 312 now. Is that correct? Close to $312,000.
great job.
And that's money actually put in the pocket of working people,
Excellent.
to be
Absolutely.
clear.
Thank you. Thank you, Madam Chair. I'd move approval if
Congratulations. Yes,
there are other
Commissioner.
I
questions.
just had one more question about the repeat offenders. I appreciate the list that we have here.
Yes.
I don't know if those are repeat offenders or just
I believe,
all of the offenders.
that's all, but if you see a name twice, then that's a repeat.
Oh, okay. Because we talked about making sure that the county itself is not doing business with people that have been found to be a repeat offender in this.
That's correct, Commissioner. And one of the recommendations that is in the proposed amendments before you, and that should this be successfully approved, would be not a per se total ban, because purchasing wanted to be clear that there might be circumstances where, for necessity of the county, they need to do business with the entity, but that ordinarily a firm that's been found to have engaged in wage theft in an order through the process where there's a determination wage theft occurred could be deemed non-responsive, not responsible as a bidder or a contractor to county business, and therefore not likely to do business with the county.
Okay. And is that something that purchasing will check on before we sign a contract with someone? A local someone?
Well, we could
is that gonna
provide,
be
we
part of their
certainly could provide,
process?
as we've done for you, we could certainly provide on a quarterly basis a list of those employers against whom a wage theft determination has been entered, and that'll help them facilitate compliance
And you can
and
provide
checking
that
to
to
see.
purchasing?
Yes, ma'am.
Okay, cool. I'll second that motion that was made 5 minutes ago.
Could I ask for whether that would include the amendment?
It includes this latest amendment, and can we get it electronically, please? If y'all could send it out to us. But I would also ask that they come back with the repeat offender notice of employer and posting for discussion, as soon as practical.
We could do that, Commissioner.
Thank you.
Great.
We can do that. Yeah, we can do that. I don't need to ask the lawyers, I'll do that.
I don't know. Be careful.
So we have a motion by Commissioner Welch, a second by Commissioner Gerard. Are there any other questions, comments? Okay. Thank you.
Thank
To
you.
you and your staff.
Thank you.
Paul.
Happy New Year, Commissioners.
Okay, public hearing is closed for this, and it's a unanimous approval. Thank you. And Commissioner Welch, I think you brought this idea.
I did, and that was in partnership with Councilmember Darden Rice down in St. Pete.
Yes, thank you very much.
Sure
It's
thing.
proven to be very successful. Okay, agenda item 28.
Agenda item 28 is,
Item 28 is a quasi-judicial hearing. It's case number Z291212. All those wishing to give testimony in that item, please stand to take the oath. You swear to tell the truth in the testimony you're about to give, signify by saying I do. Thank you. This is an application of J&J Cranes Incorporated and James G. Lucina for a zoning change from L1, Light Manufacturing and Industry, and C3, Commercial, Wholesale, Warehousing, and Industrial Support, to M1, CT, Light Manufacturing and Industry, Transient Accommodation Overlay, with a development agreement limiting the use of the property and a special exception. The public hearing has been properly advertised. The affidavit of publication has been received for filing. No correspondence has been received. The matter is properly before the board to be heard.
Okay, we have just one card in support from John Landon.
I'm here to answer questions.
Is there anybody else who wishes to speak on this agenda item?
I'm here as the attorney on behalf of the applicant.
I can't hear you. Can you speak up, please?
Sure, I'm here as the attorney on behalf of the applicant.
Okay, all right. Are there any questions or, yes?
Just one
Commissioner
quick
Evans?
question. Does the M1CT also, that still allows light manufacturing, so we're not diminishing the amount of light manufacturing area, it just opens up what we can use it for. Is that right?
Good evening, Glenn Bailey, zoning manager. Under this specific case, the development agreement that's attached to it would limit the use to a hotel and a restaurant. It would not allow anything else unless it comes back to you to remove the development agreement.
Okay, so
That's the way it was drafted.
And so staff's rationale from giving up light industrial is
It's not changing the land use, it's still employment.
still employment? Okay, thank you.
I have one question, and I was trying to look at the plans, and I was just trying to figure out how they're going to access the property. They're not going to access it directly off of Ulmerton, right?
No, my understanding is they're going to have an access to the west side of the property, if I can pull up the... So, let's see. There's a driveway on the west side of the property. That would be the main access and go through there. It would not be directly on, it wouldn't cut any new driveways on Almerton Road.
Okay, I just want to make sure that this didn't provide one more
Yeah, we'll certainly be looking at that in site
problem
plan
on
review.
Almerton.
No. And they did a traffic study and all that. If you need
I saw the
questions.
traffic study. Thank you, Mr. Pergolesi. Anyone else have any questions? Okay, thank you. Then I will close the public hearing.
Move approval?
Second.
Motion by Commissioner Gerard, second by Commissioner Long. Okay, unanimous approval. Okay, very good. Item 29.
This is case number LU 30-1218, application of Clearwater Car Wash LLC for a land use change from residential low and preservation to commercial general and preservation. The public hearing was properly advertised. Affidavit of publication has been received for filing. No correspondence has been received. The matter is properly before the board to be heard.
Okay, I have no cards on this agenda item to speak from the public. Does anyone wish to speak on agenda item 29? Okay, is there any questions by the county commission?
Move approval.
Move approval. Motion by Commissioner
Second.
Peters, second by Commissioner Long.
I didn't hear that.
Okay, passes unanimously. Moving on to agenda item 30.
This is a quasi-judicial hearing. This is case number ZLU 31-1218. All those wishing to give testimony in the case, please stand to take the oath. You swear to tell the truth in the testimony you're about to give, signify by saying I do. It's an application of Pinellas County and Girl Scouts of West Central Florida for a zoning change from AE, Agricultural Estate Residential, RR, Rural Residential, R2, Single Family Residential, R3, Single Family Residential, RM5, Residential Multiple Family, 5 units per acre, RPD 2.5, Residential Plan Development, 2.5 units per acre, RPD 5, Residential Plan Development, 5 units per acre, PRM, Preservation Resource Management, and AL, Aquatic Lands to PRM, Preservation Resource Management, PC, Preservation Conservation, RBR, Resource-Based Recreation, FBR, Facilities-Based Recreation, and AL, Aquatic Lands, and a land use change from residential low and preservation, resource management to recreation open space. The public hearing was properly advertised. Affidavit of publication has been received for filing. No correspondence has been received. The matter is properly before the board to be heard.
I have no cards on this particular agenda item, and this is the first of 2 required public hearings. The second hearing for adoption is proposed for February 26th of 2019. Is there anyone in the public that wishes to speak? I'll close the public hearing and see if any board member has any questions.
Move approval? Second.
Okay. I might like to see the site plan of what's planned here.
I thought you said this was first of
It
2.
won't be adopted
It is.
until,
You technically don't need to take any action other
Action.
than just taking public comment should there be any.
right. You want to come? This is both Pinellas County as well as the Girl Scouts, and I didn't know whether you had,
There's no site plan with a rezone, but I can go over basically, so what it is now, this is what it is proposed to be. What it is now is a whole melange of residential. It was in place when the county purchased the property. This is the coastal addition up here. The part that's not open to the public right now. The part that's open to the public is down here. Here's the Girl Scout camp. So basically, the preservation conservation denotes the areas of wetlands. That's not going to be touched by anything. Aquatic lands, the tidal wetlands in this area here. The RBR, resource-based recreation, that's mainly going to be trails. It allows playgrounds, picnic tables, things like that. The PRM, preservation and resource management, really only allows trails, so it's less, even less than a normal, typical park would be. So it just allows trails. As far as what's specifically allowed or specifically going to be proposed would be the Parks Department. Perhaps they could, there's a master plan that I think they have, but I don't have that with me. A lot of it's based on, this area up here was purchased with FCT money, the grants from the state that required certain amenities, with splash park, things like that. Splash parks, the more intense recreation is for the facilities-based recreation area in here. This is an old subdivision the county purchased about 10 years ago. And as far as the land use goes, the reason these were, in 2009, when county made a major purchase, we changed the recreation open space land use. There were all land use changes. At the time, we didn't have recreation zoning districts. That's why we're coming back right now to make it compatible with the future land use map. So, but gist of it is, the RBR areas, it's mainly trails. FBR might have a little more there, like a splash park or something like that.
I was just mainly remembering, and I'm sure Commissioner Welch can as well, back when we were looking at doing more intense recreational, and the neighborhood surrounding was not very pleased about that.
Right. This area up here along this neighborhood would not see anything like that.
Right. So this will be less intense, so we listen to the neighborhood and...
It's not in the subject area. This is still privately owned. There's some homes in there.
Okay.
But that's...
Small parcel. Okay, and then do you know what the Girl Scouts are planning? Some more cabins or?
They just went through a special exception process to put more cabins in there, and if we do this zoning change, they wouldn't have to go through that process anymore. There's really no opposition to it. It never has been. There's really nobody in the surrounding area bought the county park, so it's just something that they wouldn't have to go through that process. If they wanted to add another cabin in the future, that's why they were interested in changing it to RBR or FBR in this case. So.
Great. Thank you.
You're welcome.
All right, so this doesn't require a vote, and we will move on to agenda item 31.
Item 31, also a quasi-judicial hearing, is case number Z281218. Those wishing to give testimony in this case, please stand to take the oath. You swear to tell the truth in the testimony you're about to give, signify by saying I do. Thank you. This is the application of Velma J. Mariani Revocable Trust and Paula Mariani Asawa, trustee, for a zoning change from RR Rural Residential to R2 Single Family Residential. The public hearing was properly advertised. Affidavit of publication has been received for filing. No correspondence has been received. The matter is properly before the board to be heard.
Okay, very good. I have two cards of both individuals who are in favor of the project. I have none in opposition. Michael, you want to come? You're the applicant?
I'm the applicant's representative, Robert Pergolizzi with Gulf Coast Consulting.
I don't think we need a presentation unless there's
Just
questions.
here to
I just
answer any
wanted to make
questions you
sure
have.
that we acknowledge the public. Sandy Hartman was the other person who was in favor of the project. You wish to speak? Okay. All right. Anybody else in the audience wish to speak? We'll close the public hearing. Are there any questions?
Just a quick question.
Yes.
The zoning, the piece of land that we're talking about is basically going to mirror the strip of land that's across the street as far as the density?
Surrounding land use.
Yes.
Thank you.
Move approval? Second.
Motion by Commissioner Gerard, second by Commissioner Long. Sorry, my computer screen went blank. All right. Okay, this is approved unanimously. Okay, agenda item 32.
Item 32, quasi judicial hearing, case number ZLU 220918. Those wishing to give testimony, please stand and take the oath.
Okay.
All right.
Very
You
good.
swear to tell the truth in the testimony you're about to give, signify by saying I do. Thank you. This is an application of Cheryl M. Haynes and Patrick Shaughnessy for a zoning change from R2 Single Family Residential to C2 General Retail Commercial and Limited Services, and a land use change from residential low to commercial general with a development agreement limiting the use of the property. The public hearing was properly advertised. Affidavit of publication has been received for filing. One letter in opposition to the application has been received, and one letter and a petition with 127 signatures in opposition were received in connection with the local planning agency hearing. The matter is properly before the board to be heard.
Okay, we have quite a few in opposition and 2 in favor. So per our public hearing procedures, the applicant will have a total of 20 minutes, including rebuttal, to present their case. And is that you, Mr. Pressman?
Yes. Did you want
Okay.
to hear from staff first? Did you want to hear from staff first?
Excuse me?
Did you want to hear from staff first?
Sure, sorry.
Whatever's your preference.
This is my first public hearing since I got back in the saddle as chair, I believe.
All right, Glenn, you're up.
Riding a bicycle.
You're on a roll.
Mr. Pressman, you've been at it a long time. You know the drill.
Hi, Glenn Bailey, zoning manager, planning department. So the case subject area is 1.92 acres at 12909 Park Boulevard. That's near the intersection of Park Boulevard and 131st Street North, or Bond Road. Future land use map amendment from residential low to commercial general. That's residential low allows 5 units per acre. Commercial general allows a wide range of commercial uses. Zoning atlas amendment from R2 single family residential to 7,500 square foot minimum lots to C2 general retail commercial limited services. And it also includes a development agreement, which I'll get into in a moment. The existing use in the property is a single-family home, and the proposed use is a self-storage facility per the development agreement. And that development agreement will limit the use, again, to a self-storage facility only at a maximum height of 15 feet. Normally, C2 would allow up to 45 feet. And illumination on the site should not impose into neighboring properties. The storage units that abut residential must have doors that open toward the interior of the facility. The residential is on the east side. I'll show you that in a moment. Structures facing the residential must have residential embellishments. Vehicular access for loading, unloading must be away from residential toward the interior of the facility. Buffer next to residential should have 1 tree per every 30 feet at 7 feet high at time of planting. Site access controlled by a gate, and security cameras are required. Essentially, they're trying to remedy any effects on the residential on the east side via the development agreement. You see the location. You see Park Boulevard going east-west, 131st Street north going north-south. This is the old location of Spoto's restaurant back in the day, a couple decades ago. It's now a Winn-Dixie shopping center. It went into place in the 1990s. The actual location of the subject property is Spoto's. I guess he lived beside the restaurant at the time. So it's a fairly large house, one single-family home here. You see to the north and to the east are all single-family residential. Across the street is mostly single-family residential with a smattering of institutional uses and an ALF down there. A couple churches along the Park Boulevard corridor, which is mainly residential with a couple of commercial nodes along the major intersections. And you can see that here in the red, you see the existing commercial general land use in this commercial node here. The light blue is institutional uses. There's a cemetery and some school uses up here. The dark purple is as an office use, and the yellow here is your residential. The beige color is even lower density residential. There's another commercial node on down near Oakhurst Road. And the darker brown is the residential multifamily uses. So essentially it's mainly residential with commercial nodes in this area. As you can see, if it was approved, it would expand the commercial node to the east in this area right here as commercial. There's some site photos. It's looking west on the left along Park Boulevard and looking east on the right along Park Boulevard. See, it's across the street. You see the low density residential character of the area. And right here, you can see the shopping center and one of the out parcels of the shopping center next door to the west. It's looking south again across Park Boulevard. On the left, on the right is subject property from Park Boulevard. It's got a large front yard and the house is on the back of the property. Back here, it's almost hard to see from the road. East side of the subject property, it directly abuts 4 residential homes right now. And on the west side of the subject property, you see the driveway. On the other side of that wall is a parking area for the Winn-Dixie Shopping Center. Some additional information. The R2 zoning on the property has been in place since 1977. The commercial node that it's next to has not expanded since the 1970s. It's been very static throughout the past few decades. And the proposed development agreement does not include a concept plan nor building elevations, so we don't know where the buildings are going to go or what they're going to look like. And staff recommendation is that the proposal is inappropriate. There's compatibility concerns. Commercial encroachment into residential, again, directly abuts 4 residential homes on the east side. It's a disruption of long-standing balance of uses and designations of the area. And the development agreement provides some additional safeguards regarding the buffers, things like that, but it does not show the placement of structures nor what they will look like. And it's inconsistent with the comprehensive plan and staff's viewpoint. Staff recommends denial of the request, and the local planning agency unanimously recommend denial as well. Is there any questions?
Any questions? Mr. Justice.
Thank you, Madam Chair. Couple of things. One, I just wanted to clarify. This building wasn't the actual Spoto's restaurant, was it?
No, it was where the Winn-Dixie is.
Okay, that's what I thought when you, then I misheard.
This was his home.
It was a
the way I
big home,
understand
so
it.
I wasn't,
Right.
it's been a long time since I was at that Spoto's. And then on the property line, there's a changing of the residential to commercial. And just north of it, there's one green square that's still residential, right there.
Yes.
But on the aerial, it doesn't look like there's any access point. So I don't know if that's owned by the same property owner or if that's...
That's the retention pond for the shopping center.
Oh, it is,
So
okay.
that can stay residential. So-
Okay, all right. That's what I was curious about. Thank you.
Right. You're welcome.
Okay, any other questions?
It's hard to see there, but that's what that is.
Yeah, you can see it on the Google Earth pretty clear.
Okay, great. We'll call you back up if we need some help. Thank you.
You're welcome.
All right, now it is the applicant's turn.
20 minutes, right?
Thank you. Madam Chairman, Mr. Administrator, County Attorney, my name is Todd Pressman, and I'm at 334 East Lake Road, number 102 in Palm Harbor, Florida. I'm here with Pat Shaughnessy and his wife. This is their application before you. Madam Chair, Commissioners, I'd like to ask you one question up front. Would you like to live next door to, directly next door to, a very busy Winn-Dixie supermarket that's open from early in the morning to very late at night? Now, your staff gets it right 98% of the time. We do believe this time they missed a mark, because that is really what's at issue here. So I do have a PowerPoint for you that I want to walk you through. I'm going to show you much different pictures than what you've seen already. I want to orient you to the site and the issue a little better. As you know, we're in the Seminole general area. So what you didn't see is that the existing site, which is in green here, is right next door to Winn-Dixie store. So to even say that the area is predominantly residential, we believe is absolutely incorrect. You can see we have C2 zoning right next to the residential zoning, right next door. That's pretty rare to see. We're proposing a rezoning land use to allow one single use, a mini storage use that's written in stone by the development agreement, which is currently residential. This is standing on the property. This is what's next door from 7 a.m. to 10 p.m. So I'll ask you again, is this where you would like to live? It's not appropriate for residential anymore, and it hasn't been for a long time. Lots of vehicles coming and going. It's a whole shopping center, bringing a lot of movement, activity. Now, this is a shot from Winn-Dixie. As you can see where all the truck activity is, where all the products are delivered, where all that activity of loading and unloading occurs is right on the property line. And you can see the existing house, which is on the property right there. Again, 7 a.m. to 10 p.m., the store is very busy, very active. Again, you can see another truck there with their delivery. And this is the whole shopping center. Right next door to the side is a jewelry store. You can see that there's a for sale sign on. They have a long history of trying to sell the property. I'll tell you more about that in a minute. And then this is the lighthouse that shines on the property all night long, or how long the lights are on for the sign. I don't know the hours, but obviously it's late hours. This is the subject site. You can see the home in the back there. And it's a nice home. I have an arrow there showing you how close it is to the Winn-Dixie on the delivery side there. It's a nice home. Shaughnessy's have tried to sell it for a long time. It just has not sold. It's been kept up well. So that is the status that we're in. As well, on Park Boulevard is a very busy road, and you saw from the zoning map that there's plenty of C2 and there's plenty of public, semi-public on that roadway as well. So what we did is we went back and we made major changes. We added significant restrictions and conditions through a development agreement to guarantee just the use, mini storage, illumination downward, vehicular access is controlled away from the residential, control gate, security cameras, limit the height to 15 feet, structures facing the residential will have residential embellishments, and a buffer tree at center for every 30 foot at 7 foot high when planted. Now compared to residential, because that's what we're comparing it to. If you deny it, it will stay residential. We believe this is much better than what residential could be to the neighbors who have concerns. And we have great respect for the neighbors. We're trying to find a use that's a step down from a very intensive commercial use. Mini storage is very quiet. The only thing that has more trips or has less trips than a mini storage is a cell tower. That's how little activity there is, how little noise there is. But residential to residential is not always the greatest fit. When we compare what we're proposing of residential versus self-storage, we believe we're a much better neighbor. Because residential, a home could be built to 40 or 45 feet high, towering over the homes that are there now. We're restricted to 15 feet. There's no fence. There's no buffer between residential. This would require a 6-foot fence. The setback for residential is only 6 feet. If this is approved, it's 20 feet behind a fence. No landscaping of residential, and there is landscaping and buffering and landscaping between the two. And there are no neighbor nightmares. And the commissioners have seen neighbor nightmares, unfortunately. They do happen. It's quiet, there's no trip, there's no late night parties, there's no loud music, there's no pool parties, there's no smokers. It's very quiet. Under the comprehensive plan talks about sites that are currently RL. We are RL. So the comp plan is telling you that these are areas where use and development characteristics are low-density residential in nature. Well, obviously next door to a Winn-Dixie and across the street from public, semi-public is not where RL belongs. It doesn't match up with the comprehensive plan, in our opinion, in that regard. So there is a history here that Shaughnessy's have tried to sell the property. It's been for 4 years. They've had 3 different realtors. They've had no success. They keep asking themselves, what can we do on this property? What will work? What will work for the neighbors? What will work on this site best? So you look at other factors. Park Boulevard is a major arterial roadway. It's a 4-lane divided highway. And under Forward Pinellas, they indicate there's anywhere between 16,500 trips to 22,000 vehicle trips per day. That's not a residential street. That's a loud, very busy 24-hour street. So when we look at the roadway, we feel that it is not appropriate for residential use in that regard. It's also not a scenic corridor. So if you look at similar uses along Park Boulevard, the site is located here. This is the Winn-Dixie. There's a CVS, shopping center, mobile, gas, pizza, ALF across the street, transmission tower. There's a church, which is a busy church doing a lot of different types of activities, and Jehovah's Witnesses. This is just a piece along Park Boulevard. This is, for example, the tower. I guess she didn't like what I was saying.
Good job, Todd.
It's not the first time I made a woman cry. This is the tower. You can see that's Park Boulevard right at the top there. This is the large complex of the church. And this is what I've shown you before, the complex of the commercial. So we did ask the current realtor to look at this site for us, and make an evaluation for us in terms of what's proposed from Berkshire Hathaway. And they wrote us a letter which indicated that the proposed mini storage would not cause a decrease in property values of nearby residents. Rather, you would see it as an increase. Again, it's a good buffer from an intensive commercial use. It's a good step down. The current neighbors being very intensive and busy operating commercial center, operating many hours a day, are a terrific negative impact for all the residential nearby. The realtor also indicates that mini storage would be extremely quiet, extremely low, impacting neighbor use that provide excellent shield. And it is extremely clear from my evaluation and a long history of trying to sell the property that the property is in no way compatible or conducive or appropriate for any residential use. That's from Scott McNay, who's the current realtor holding the property. So in summary, commissioners, the site has had the test of time. It's on Ontario Road. We reviewed it with a real estate expert. We don't feel that a residential use is the best use there. Mini use is a great store, is a great use because it will protect and shield the neighbors, will not decrease property values, and will not be impacting. We feel it's better than a residential neighbor in this regard. We provided very detailed, very intensive restrictions, conditions, requirements to make it compatible. So with that, we appreciate your attention and consideration. We're happy to answer any questions you might have.
Anybody have any questions? Okay. Thank you. I'll ask for the proponents first. The first one is Bob Matthews. And you'll have 3 minutes.
Good evening. I'm a neighbor, lives across the street, a business, Seminole Garden Florist. We've been there 18 years. The property as it is now is well cared for. It's not trash. And it's an example of what they will do if they put the storage in. And also, as you know, with the development agreement, we can put more buffer than what the law requires. So the buffer is going to have some depth to it. And then the design to keep it protected from the view as a storage facility. But it's been up for sale off and on all the years that we've had our business across the street. And I don't know how long the Shaughnessy's have owned it, but it's set over there vacant. I think it would be a good use for it. Storage is quiet. We can, with the development agreement, we can control the storage any way we want. So I think, as a neighbor and as one that would see that it would be, you know, all of us want to sell a piece of property when it's time to sell, but it's been up for sale for a while and it's not going anywhere as a residential property. But I appreciate your hearing on it and welcome. Thank you for the new year and enjoy. We appreciate what you do for us. Thank you.
Thank you. J.C. Brock.
Good evening, Commissioners. My name is J.C. Brock. I reside at 7575 Oakhurst Road, Seminole. I've been a resident of the area for approximately 35 years. I'm here this evening to speak in support of the requested rezoning as described by Mr. Pressman. Over the past 2 years during the construction of a new home, I had, like more than 10 million people in the United States, the opportunity to seek a storage unit for storage. Unfortunately, the availability was minimal in our area, and I wound up with 3 different storage units at 3 different locations. From Walsingham Road South to Madeira Beach onto the west side of Dumie, there are currently only 2 storage facilities available for that very densely populated area of Seminole, and is not adequate enough at this time. Since the mid-1990s, there's been great improvement in this self-storage industry in the areas especially of safety, security, and crime prevention. The significant body of research is available for all of us to review by professional groups in the industry, criminal justice research groups, and the National Institute of Justice. The research shows clearly the rate of reported crime at storage units is far less than those for residential or vehicle areas, crime in similar areas. The majority of reported crimes occur at facilities built before 1990, are located in high crime areas, are located in areas with inadequate lighting, surveillance, and gate access control, or on-site management. Facilities that are built into a populated area have on-site management, utilize current Technology for lighting, access, and surveillance actually improve in the crime, as far as the crime rate goes, for both residential and vehicle traffic, as well as those storage units. I believe there will be no adverse impact. The traffic flow on the major highway to Park Boulevard can easily accommodate the sporadic traffic that will have no concentrated times of use. And as Mr. Pressman has shared, this proposed project will utilize all the desirable best practices to be a positive member of the community while providing a needed service.
Okay. Thank you.
Any questions? Thank you.
Here's who is against, and Julia Picacci. Is that?
She just went out with the baby.
Oh, okay. Whoops. Okay. Meredith Johnson.
Madam Chair, with all due respect, there were two folks who did fill out cards in support.
Okay. Do they want to speak?
Yes. I'm sorry.
If you could go and fill out a card, please.
They did.
They said they did.
They did? Okay. Well, come on up. We'll go ahead and take your testimony, and I'll look for the cards.
Hello, good evening. Thank you for...
Hi.
Hi, my name is Julia Ficacci. Oh, I'm sorry.
Whoops. We
No, sorry.
we got to reset it.
Oh, I
Sorry.
wasn't sure if I was supposed to touch.
You're done.
I think she's against.
She's opposed.
Huh? She is against.
Yeah,
Her
she's
here
opposed.
with the baby, so I'm going to let her go ahead and speak.
Yes, I apologize, and I apologize to everyone else for the interruption before, but I wanted to bring the babies with me because their window actually overlooks this property, and my property borders the property that we're speaking of. It's an honor for me to stand before you because I was on the youth council to the county commissioners back in 2001, representing Seminole High School. And I moved to New York City for 15 years, and I specifically moved back to give birth here and raise my twins in Seminole so that they could also attend Seminole High School, and because it was a quaint, very quiet neighborhood, residential area. My husband and I are opposed to the rezoning of the property because it would be very disruptive. While it's called a mini storage, there's nothing really mini about it. I imagine there will be 24-hour access with either key code or fob. That's usually how storage facilities work. All hours of the night implies possible criminal activity, and safety is my main concern. So I'm coming before you tonight as a mother more than anything, and asking you to consider that the driveway that my kids play on borders the property, and there are two windows in their nursery, overlooks the property, and we don't want them growing up next to a business. And that's why I moved away from New York City. So the Winn-Dixie, we knew it was there. It's actually something that we walk to. It's convenient, it's quiet, but a storage facility just wouldn't be conducive to the nice community feel that we have, the residential peacefulness that we currently have. That's basically all I wanted to share tonight. Thank you for
coming this evening and bringing your child.
Okay.
Thank you. That's especially if it's noteworthy and difficult, I know. I think I may have the cards. They were mixed up with the other ones. I'll make sure Jane Little and Jeannie White. Okay, sorry about that. They got mixed in with the against. So since you're for, would you like to start? Hi.
Hi.
Sorry about that.
Oh, that's okay. My name is Jane Lytle, and I am the manager at Oak Tree Manor Assisted Living Facility, which is owned by the sister of the applicant and which is located directly across the street from the proposed site. I have worked with Oak Tree for 18 years. Being located right across the street for over 20 years, I can tell you that this immediate area is not predominantly residential. In this exact area along Park Boulevard, you will find all kinds of commercial businesses, including drugstores, gas stations, retail shops, offices, restaurants, churches, and some residential, yes. It has been my personal experience that most self-storage facilities are generally quiet operations with very little traffic entering and exiting the facility and relatively little noise during the hours of operation. Take, for example, our ALF, which is quiet and non-impacting. A mini warehouse would be even less impacting than our ALF. Furthermore, our facility acts as a great sound buffer to the homes behind us, keeping it quiet for the residential neighborhood to the south of us. One last thing. The last place I would want to have my home is next to the Winn-Dixie. It opens at 7 a.m. and it stays open till 10 or 11 at night. The parking lot is always well used and there are often car alarms going off. In addition, the parking lot is well lit when it's dark. I often go there to pick up something for lunch and dinner, and the store is literally always packed. There's no way a residence literally belongs right next door to all that noise and commotion. It's not fair to ask anybody to live next to that. The residents on that side of the street would benefit greatly from having a sound buffer that would be provided by the self-storage facility. We urge you please to support the application. Thank you.
Jeannie White? Again, sorry about that.
Okay, go ahead. So my name is Jean White, and I'm actually here on behalf of Joseph Racy, who lives at 7651 128th Street in Seminole. He was unable to attend tonight, so he asked that I read this letter that conveys his strong support of the issue and application. Dear Commissioners, I write this letter to express my complete support for the application that is before you this evening. I have lived in the vicinity of the site since 1996 and am very familiar with its location and the surrounding properties and businesses. I believe that this is a great use for the property. It has been underutilized for years as there has been no interest by anyone to live there. I further believe the lack of interest is a result of improper zoning. History predicts the future, and denying this application will ensure the property remains underutilized, which is unfortunate and needs to end. There are plenty of safeguards in place to support a zoning change, which will allow the property to move forward and make it a positive contribution to the community. From my perspective, as a resident in the immediate area, this application is a move in the right direction and request that you support it with your vote tonight. Sincerely, Joseph Racy.
Thank you very much. Okay, we're moving back to those against. Meredith Johnson. Hello.
Hello. First time. I'm a little nervous. My name is Meredith Johnson, and I live at 13067 Farmington Trails. I'm here to take opposition to the rezoning of this property. I've been a realtor broker in the Pinellas County area for 18 years. With my sales experience, my professional opinion is that any residential property will sell if it's priced correctly. Mr. Pressman has said that this property will not sell because it is next to Winn-Dixie. The reason the property has not sold is because it has been priced too high. If this property was priced where the market dictates, it would sell just like any other residential property. I have personal knowledge of this property. My home borders the north side of Winn-Dixie. My 20 neighbors and I purchased our homes with Winn-Dixie as our neighbor. This fact did not prevent us from buying our homes. It was simply a factor in the sales price, as it was for Mr. Shaughnessy when he purchased this residential property. So it looks like he's had it listed twice, starting at $899 with several price reductions. The last price being $759, which expired. That was, as the list date for that price was 5/24/2018. The home's worth about $550 according to my comps. The back house, which is 1,650 square feet, is not considered part of the main property. So in the MLS listing, they have it as 5852 square feet, where the house is 4202 square feet with a detached semi-finished mother-in-law suite of 1,650. So the price at $759 $759,000 is $129 per square foot. So if you take the $129, I rounded it up to $130 to make my math a little bit easier. If you take that $130 per square foot and multiply it by the 4202, which is the main house, you get $546,260, $546,000 and $546,260. I gave the additional structure in the back a value of $60,000, which equals $606,260. So I would love to sell it for him for $600,000 if he'd let me. It's not worth $759. So being a neighbor and a real estate broker in the area, that's all the information I have for you. Do you have any questions?
Question? All right, thank you.
Okay, thank you.
All right, Patty Gaston. Nice to see you again.
My name is Patty Gaston, and I live at 12785 Park Boulevard. I'm here today to oppose the rezoning of this property. We have 129 neighbors who all signed the petition that oppose this rezoning. These families live in homes that surround the property, living to the east, west, north, and south. We are here asking for nothing more than to keep our neighborhood residential. The property in question has been zoned residential since 1977. When the applicants purchased this property in 2012, they knew that the Winn-Dixie was abutting on the west side. They bought this as an investment property and have never lived in the house. County records indicate homestead exemption has never been applied for since they've owned the property. They've tried to sell at unrealistic prices that the market cannot support. They bought this house on a short sale for $310,000 and have tried to sell for as high as $899,000. In their application they submitted to the county, they answered question number 13, which asked why the application should be granted. In their answer, they stated that the residential homeowners have tried for several years to sell the home with absolutely no interest. This is a lie, and Mr. Pressman signed the certificate of ownership as their agent. According to MLS, there were 2 contracts offered for this property. This verifies that there is interest as a residential property. This case and all the meetings that we have attended is based on a lie by the applicants and their agent. Here are the facts. Commercial general properties are generally appropriate in locations adjacent to major employment centers, and the C2 designation is intended to support services to a regional market with larger scale commercial buildings. This property doesn't meet either one of these criteria. Both the zoning staff and the planning board voted to deny this rezoning. Their findings were that the rezoning was not compatible with our neighborhood and would have impact on the long-standing balance of uses in this area. The research that we have done supports that there is no need in our neighborhood for another storage facility. Within 5 miles of our neighborhood, there are 14 storage facilities. I have a map here. Shows you, they're all numbered. The closest of these is a mere 0.3 of a mile away. It consists of 155 units, and the owner stated that it's never full. The next closest storage facility is a really large one. It's the I-Storage. It's 0.8 of a mile from our neighborhood. This is a 2-story structure. It's 45,000 square feet in size with 536 units. This facility also has uncovered storage area for boats, trailers, and RVs. The manager told us that there is always availability there for people needing to store anything. Crime is a reality with storage facilities. Burglary, loitering, drug activity, and people living in units are just some examples. As you can see on the map, there's the closest one, there's the I-Storage. We have 14 facilities in a 5-mile area. The numbers in orange are less than 1 mile away. Pink is under 3 miles away. Green is under 4 miles away. And yellow is 5 miles away or under. These 14 storage facilities with the 6,996 total units show that there's not a community need for another storage facility. The property managers at these facilities all said that there were a lot of available units for rent. Mr. Pressman showed you a slide in his PowerPoint that implies that having a storage facility is better than having a neighbor. How ridiculous is that? To try to make a case that a commercial property is better than a family is just really a desperate tactic. If this property is rezoned, it will be an encroachment into our residential neighborhood. Will you vote to spot rezone a property just so individuals can make more money than it would sell for in a residential sale? Because really, I'd like to know, because I live in one of those homes that Mr. Pressman thinks isn't very good on Park Boulevard. It's very similar in size and location. So if I put my house up for sale for $899,000 and I can't sell it, will you allow us to rezone to commercial? If you support their rezoning request, it would be spot rezoning. Mr. Pressman and the applicant sent a letter to the homes in our neighborhood. The letter stated that we are all neighbors. Applicants are not our neighbors. They live on the Intercoastal in Bel Air. All of our neighbors' quality of life and property values would be negatively affected if this rezoning is allowed. Mr. Pressman has also stated previously that our opposition to the rezoning is personal. All of the 129 people that signed the petition opposing this rezoning would feel the same way regardless of who owns that property. We only care about keeping our neighborhood residential, and it's just that simple. This is nothing more than an attempt by the applicants to profit at the expense of our neighborhood. We ask that you put yourself in the shoes of the 129 neighbors who signed the petitions against this and vote to deny this rezoning. And I'd like to ask all my neighbors that are here opposing to please stand. Thank you for your time.
Okay. Thank you. And we had allowed 10 minutes because you were a group speaker. So thank you very much. Next is Guinevere Pettyjohn. Hello.
How are you? I have a slideshow. It's called Park Boulevard. Whoever does that. My name is Genevieve Pettyjohn. Good evening.
Good evening.
How are you? I have to get used to wearing these now. I told my husband I need a chain. My address is 7955 128th Street. I'm here today to oppose the rezoning of this property. I've lived in this neighborhood for 12 years now. It has falsely been stated that this house is surrounded by commercial property because it sits on an arterial roadway. The PowerPoint that I am about to show you goes from Ridge Road to Oakhurst, and it's about a 3-mile stretch. I'm pretty much going to show you actual pictures of this, and if you want to just take a look at it, I'm not going to talk specifically about each picture, just kind of talk about the area. So as you can see in this 3 miles of Park Boulevard, it's full of residential corridors. It is interspersed with 3 churches and a few multifamily dwellings. Is it going? Okay. The only commercial nodes are at the intersections. This portion of Park Boulevard is a scenic route to the Gulf beaches. It's not a commercial corridor, as Mr. Pressman would like for you to believe. As you can see in these pictures, and as you could see in his actual slideshow, it's not surrounded by commercial. Most of it is surrounded by residential. Residential homes are continually sold along this section of Park Boulevard. A new home is being built across the street from this property right now. The assertion that this house can't sell residential is just a lie. The facts tell the truth. If Mr. Shaughnessy lowered his price, he could sell this as a residential property. The only reason he is requesting a rezoning to commercial is pure greed at the expense of all of our neighbors. Thank you very much for listening.
Thank you. Debbie Raines.
Madam Chair, can we get an address, please?
My address, 7955 128.
Good evening. Debbie Raines. My address is 7925. She's my neighbor. 128th Street. I grew up at 12533 Park Boulevard, which is 0.3 miles away from where I live now. I went to college, came back, moved into the same residential area that I grew up in. I have lived at this current location for 25 years. Raised my family. Both of my children are in college right now, and they begged me, please do not sell the home, because Mom, that's where we want to come back and live. Okay. Went to Seminole High School. I have a couple of things, and I'll try and make it short and sweet. First of all, it makes me wonder why we have not heard from Mr. Shaughnessy himself, only through his lawyer. I would like to hear his emotional statements on the reason that he bought this property in the first place. When he purchased this property, Winn-Dixie was there. All the things that were there when he purchased this property. As you've heard previously, he has not spent a night in this property. I want to know from him, what was in his mind when he bought it? Did he plan on living there? Did he plan on selling it originally? Was his original thought to go ahead, purchase it at a quick sale, and turn it around and who knows, make a quick buck on it? I don't know. So I would like to hear specifically from him exactly what his plan was when he originally bought this property. A couple of the other issues, as I told you, I grew up in that area. My mother, up until August in 2017, she lived at 12533, which is Park Boulevard, which is just 3 houses west of 125th Street. Sold her house 36 hours in August of 2017. So the idea that we can't sell a house right there in this immediate area, if priced correctly, as everyone has been saying, the house will sell. She got quite a good price, fair price for her home prior to going into an assisted living facility. I guess that's about all I want to say. I don't understand. I guess I just really would like to hear from him what his original intentions were. Okay? Obviously, I'm opposed.
Thank you. Dan Babbitt, and then after Dan is Mary Getchell.
I have a PowerPoint. My name's Dan Babbitt. I live at 12822 80th Avenue in Seminole. I am opposed to this proposal. With all due respect to the proponents, they paint a different picture with the same words and the same pictures I'm going to present. This is the property, nice property, lots of trees.
We're not seeing it. Okay.
You noticed house for sale, but why won't it sell? Well, let's take a look. These are nearby properties. As you can see, their prices, they are selling, and they're right in the very same neighborhood we're talking about right now. So let's review. As my colleagues have stated, there's a history behind this property. You can see it was bought in 2012, $310,000. Followed within 6 months, almost triple the cost to buy that property. And yet, there were pending sales. There were opportunities to sell. If the original intent of the current owners was to rezone it, why wasn't it done way back then? But here we are. And now, here it stands, still unsold. The reasons are fairly obvious, as my colleagues have stated. So what happened? What happened in 2012? What did it look like? Well, if you look, you can see this area over here. Very nice. Look what happened. Over here, there's a difference. What happened to the trees? There's a buffer zone there, protecting you from light from Winn-Dixie. And oh, by the way, Winn-Dixie's deliveries are made way over here on the left side. So the picture that was originally presented of them being made out front was very, very much jaded. Deliveries are made over here. The lighting is not affected. So what did happen? You hear this word buffer tossed around. The word buffer is over here because the buffer was there until the trees were taken out by the current owners. Okay, before and after, same place. Okay, before, and this is what it could become. This is what it could become because the detailed plans were not presented. There's vague outlines of what this proposal will look like. Maybe this, maybe that, but here's what it could look like. How is that compatible with a comprehensive land plan? How is that with the future land use? The spot rezoning would turn into something like this, which is not residential, which does not comport with what it should be. If you look, You may have heard mention of the facilities which are already there. These are what they look like. Less than 3/10 of a mile. It's a long golf shot from the front desk or the front yard of where this property is. And again, a much larger facility. Vacancies are there. They're already there. We have to all play by the same rules. The same rules say comprehensive land plan must be followed in all respects. He's proposing to plant a tree every 30 feet or so. But again, as you look at it, the trees are already there. Why take out trees to put in more trees? Why put down concrete to put down what could be there? It's already there. It's a home. It should stay a home. It just has to be at the right price. Thank you.
Okay. Thank you. Mary Getchell? And then Glenn Getchell?
I do have some maps as well. So yeah, my name is Mary Getchell. I live at 7840 100th Street North. Let's see, I'll show you on the map where I am. Is that right? Can you see that? So, we are over here, and this is his property. So my husband Glenn and I bought our first home together almost 14 years ago in 2005. Glenn was very diligent about researching the area and this neighborhood. We knew there could be no potential for land to become developed with more homes since it was residential property, but not to become commercial property. The day we bought our home, it looked, again, as he showed, this is similar as his, but it looked very, a lot of trees. You can see this aerial view that was taken April of 2012. And then when Mr. Shaughnessy bought it in December of 2012, he basically clear cut it. Again, you can see all that. Again, our home is here. Before it looked like that, and now it looks like this. So now he wants to turn it into a storage facility that might look like this, only 30 feet from our home. So I ask you, would you want to live next to this, to look out your kitchen or bedroom window every day to see this? Honestly, do you think this would be an enhancement or detriment to your home, community, neighborhood if this was to be built less 30 feet from your house? Mr. Shaughnessy knew Winn-Dixie was next door and knew what he was getting into, yet he took the risk just like any other investor. He claims he cannot sell it, but he had not reduced the asking price a single time on its last listing, which lasted nearly half a year. And now it's been off the market for a quarter of a year. Our neighborhood will not benefit from this land becoming commercial property. The financial return of one person should not outweigh what is good for the entire community. And as you heard from the others too, there's plenty of storage facilities close by. So that's all I have. So thank you very much.
Thank you. Glenn Getchell? And then thereafter is Delane Ward.
My name is Glenn Getchell, and it might surprise you that I live in the same house that he does. Okay, I stand before you tonight after already attending 2 previous zoning meetings with my neighbors at our expense of time, loss of work, and money in an effort to protect our way of lives, our homes, and even our nest eggs. Despite the zoning department not recommending this plan, the property owners and Mr. Pressman have charged forward, adding unneeded stress and hardship to our lives in an effort to have you, the county commissioner, bail these real estate flippers out of an investment that is not working out as they had hoped. Well, I suspect many of us here have investments that have lost significant money in the past year. It seems silly that we should be able to ask the county to make a change to our portfolio to make up for our bad decision, luck, or just the market. But that is exactly what this real estate investor is asking you to do by allowing him to rezone a long-standing residential property just so he can make a buck. Mr. Pressman, a hired gun, would have you believe that this commercial property is no big deal, and in fact better than a residential property for whatever bogus reason he can come up with at the moment. However, Mr. Pressman did not choose to live next to a commercial property. I know, I checked. The investors who have brought us here did not choose to live next to a commercial property. I know, I checked. And from what I can tell, Not a single member of this council chose to live next to a commercial property. I know, I checked. Why is that if living next to commercial is so great? Mr. Pressman says this property must be rezoned because it's unsaleable. That is not true. What Mr. Pressman doesn't want you to know is that there have been at least 2 contract pendings on the subject property per MLS. He will say that these were lowball offers. Let me be clear. Contract pendings are not offers. They are fully executed contracts. They are meetings of the minds. Why the deals fell through are not known to us, but the fact remains this house was under contract at least twice, despite the owner's claims of unsaleability. Who knows how many offers there actually have been. This entire hearing is about an investment gone wrong and an investor trying to salvage it at the expense of others, while I'm offering them a way out of this unsaleable property. I am a licensed real estate broker and a state-certified real estate appraiser with over 30 years' experience. I am making them an offer right here and now to purchase the property, as is cash, for exactly what they paid, allowing them to get their initial investment back. The only contingency being an acceptable home inspection due to the rumors regarding why this previous sales may have fallen through. I will close on this before the end of March. I have a letter here from my money manager proving I have access to funds. So here's an offer to purchase this unsaleable property for exactly what they paid for it, proving it is in fact saleable. And remember that the owners want to bulldoze the 2 structures at a cost of tens of thousands of dollars. So not a single improvement they claim to have made to this property is worth a penny in their minds. So they can either take my offer here right now and make this hearing moot, or they can prove that we the neighbors already know, which is that this hearing is about their greed at the expense of others. I ask you, where is their moral hazard? Thank you.
Okay. Thank you. Delane Ward?
Here's the contract.
Okay. Ooh,
You just refused the offer.
that was a little unnecessary. You think? Okay. Delane?
Hi, how are you? Hi, I'm Delane Ward, and I live at 7675 DeLong Way in Seminole. I'm here today to oppose the rezoning of this property. Mr. Pressman has stated at previous meetings that he doesn't think homeowners on the south side of Park Boulevard, which is where I live, directly across the street from where this proposed property is, should be concerned with this rezoning, as they are not neighbors. We all received a county letter advising us of this rezoning request, and also received a letter from Mr. Shaughnessy indicating his desire to rezone this property. I don't think Mr. Pressman can have it both ways. All of us would be negatively affected by the rezoning of this property in our neighborhood. I would like to give you a brief history of the Winn-Dixie property and residential property they are trying to rezone. There was a restaurant on the Winn-Dixie property in the early 1970s. The restaurant was named Spodo's Stockyard Inn. The man who owned this property, Bob Spodo, built his family a home on the property that abuts to the west in 1977. The restaurant burned down in 1993, and Winn-Dixie was built on this property in 1996. The Spodo family home was sold twice in 1990. The sale in August of 1990 resulted in the Ham family living in this home. The family fell under hard times during the 2008 financial crisis and ended up selling this home through a short sale in December of 2012 to Mr. Shaughnessy for $310,000. He bought it as an investment. He had grand plans to make a big profit on this purchase, as he still does to this day. We know that because he immediately priced this house to sell at $899,000. When he realized it wasn't going to sell at that price, he decided to rezone and make easy money on a storage facility. The property has been a residential dwelling for 41 years. Winn-Dixie has been next to this property for 22 years, so why is this the problem now? The only reason that Mr. Shaughnessy wants to make more money by rezoning to commercial, and as he and Mr. Pressman have stated, Mr. Shaughnessy wants to build a storage facility on the property. There are no guarantees that Mr. Shaughnessy is going to build a storage facility on this property because once the rezoning is changed to commercial, he can build any type of commercial business on the property within the current zones. Furthermore, he will most likely sell the property once it is rezoned to commercial because the value of the property will increase significantly. This rezoning would be an encroachment on the residential neighbors surrounding it, as well as myself, who is not a neighbor on the south side, so to speak. Don't allow this investor to enrich himself at the expense of the neighbors or any of us. Thank you.
Thank you. The next card has that they would waive speaking, but are against, and it's Tom Crowell. Is that the case? Okay, thank you. The next is Donna Chisholm, and you also said you were speaking against, but would waive speaking. Is that still the case? Okay, thank you. I just want to make sure. And then next is Joseph Caxiero. That you were registered to speak. Do you want to speak? Okay, all right. Next is Ms. Cotting. Do you wish to speak? Okay, all right. And then finally, this card doesn't say for or against, and I apologize. I can't read the entire handwriting, but it's Pat, and it looks like it starts with an S as far as the last name. And it looks like somebody who lives on North Pine Circle?
That's me.
Oh, that's you. Okay. All right. Sorry. Thank you. All right. Are there any other members of the public who wish to speak for or against? We'll close the public hearing and have the applicant come back and provide concluding comments.
Madam Chairman, Commissioners, Mr. Administrator, County Attorney, Todd Pressman, 334 East Lake Road, number 102, Palm Harbor, Florida. If we could zero in on this aerial that I have here, I have difficulty understanding, with the greatest respect to the neighbors who have come down here and spent your time, and we do mean that. I mean that personally. Shaughnessy does. We have great respect for you. We understand you have concerns for your neighborhood. I don't understand why, as I can see here, for the addresses I got, why most of these folks are so upset and concerned. Miss Gaston lives over here, which as I can see is 1, 2, third home past another street. Babbitt lives here. The third and fourth speakers, I didn't get their name, are located over here. This is the site located here, by the way, I'm sorry. This is the site located here that we're talking about. This is the Winn-Dixie. So, and Mrs. Johnson lives way over here. I don't see how these folks are affected by this request. I don't understand, honestly, I don't understand why they're here. This is about this small property here that's being impacted by Winn-Dixie. And two of the residents, Ward, live across Park Boulevard, and I asked the neighbors, Chisholm I didn't get an address, but I was also told it lives across the street, but I wasn't able to verify that. So I wonder why we're here, or why these folks are here, and what their concerns are, because I don't see how they're affected by this. But let me respond to some of the comments. First of all, the first comment had to do with trees, and I've talked to the Shaughnessy's about this. Their answer to me is that the trees that were there were Brazilian peppers, which do not require a permit to be removed. I don't know that. I didn't research it. That's what they told me. Secondly, when we talk about petitions, or 129 petitions, I then have to ask even further, why are we generating 129 petitions here? When this is a small property where there's, I have to look at the arrow, 3 or 4 residents that are next door. I don't know why this is blown up so big. I think that's important for you to have that perspective. The issues are not about, really, with all due respect, my personal opinion, who owns it, who doesn't own it, why they bought it, why they didn't buy it. It's a zoning decision. It's a future land use amendment decision. Does the zone and the use that we've cycled this down to, and we have ratcheted and drilled this down to a specific use, I won't beat a dead horse, does it belong there or does it not? I certainly understand that the neighbors have raised concerns in that manner in terms of whether it was financing, whether it was real estate supported. Those are other issues, in our opinion, that are before you. We believe that when you look at the comprehensive plan and the elements that we presented, that is what is important for the decision here. When you do look at residential compared to residential, there can be many problems. A 45-foot high structure overbearing an existing residence, they're not going to be happy with that. Zero buffer, 6 feet away from the property line. People are not happy with that. People are not happy with noisy neighbors, smoking neighbors, coming and going, pool parties. Residential is always not the greatest neighbor. So what we would suggest to you is that it's better the devil you know than the devil you don't. And we have spent a lot of time trying to figure out and bring forward what we thought was a good plan that works for this site and brings it to the level that it should be. If there's any additional questions, we'll be happy to answer them for you.
Are there any questions?
I have
Yes,
a question.
Commissioner Peters.
Thank you, I appreciate it. And so I do have some questions for you, Sue. First, I want to, one caveat. You said it wasn't a scenic corridor. I walk that neighborhood a whole lot, and I think it's a very scenic corridor. So just that from the front. But my question is, on the FEMA maps, is that a flood zone?
I really don't know, but if
It's
I may,
not. So it's not 10 feet over flood or anything like that?
I can't answer that, I don't know.
Okay. My other question is, are you gonna, if you were to put this in, you'd have to do drainage ponds as well, just like the one that's currently there?
They'd have to meet all requirements, including
Okay.
drainage.
So you
engineered by
either
the-
expand what Winn-Dixie has or create more ponds?
They would have to
Okay.
attenuate all.
And what I haven't heard is how many storage units were proposed? Number?
If, with great respect, the county designates certain roadways as scenic corridors.
Okay.
And Park Boulevard is not an official scenic corridor. You certainly, in all, of course, due respect, may feel that it is. And
I think it's beautiful.
I looked up designations, and that's what
Okay.
I was indicating. We did not work up a specific plan, so, and there's flex areas where units can be bigger and smaller, so I can't quote the number to you.
Okay.
That could be accurate.
And the reason I'm asking, and most people don't know this, but my business, my family and I have been in the storage business since the 1980s, early 1980s. And a lot of what they've complained about, and I have 243 units, we don't have neighbors complaining. And we have beautiful privacy fences, and we have sound barriers, and we don't have lights, and we close early hours. And so in my experience in my business, since the 1980s, my family has had this business and it's currently mine now. The concerns that I'm hearing just haven't articulated in my personal experience. So, but I understand what they're saying, and I understand that since the 1970s that it has always been residential. The other question I had is if the owner of the property were to sell it to a developer to build more houses, how many houses could be built on that piece of property?
It's R2. Yep. It's future land use is R2. There's 2 units per acre.
2 units per acre.
And you
okay.
don't round up.
Okay. Okay. That's all the
Mr. Bailey's
questions.
coming up.
Okay.
It's residential low allows 5 units per acre.
I'm sorry.
The R2 means it's 7,500 square foot minimum lot sizes, 80 by 70, or 80 by 70, whatever. We think it reasonable to get 6, 7 houses in there.
6 to 7, so you can
6 to
kind
7.
of get like a
Because you gotta
cul-de-sac-ish.
you gotta have a retention pond, you gotta have an access drive and all that stuff. So it could take probably about 6 or 7.
6 or 7 homes.
Single family homes.
Okay.
Then Commissioner, may I respond?
Yeah.
So Glenn is citing and correcting me on the density permissible, but when you start to put together roads and drainage, those numbers go down.
Okay.
So zoning may say, gee, you can put 10 houses in here, but by the time you engineer for drainage, roads, setbacks, buffers, that gets taken apart as you go through the puzzle.
Okay, thank you.
May I ask a question?
Are there any other questions from Mr. Pressman? The public hearing's closed. So, sorry.
He brought up something that I think is...
The public hearing is closed. Any other questions for our staff? Okay. What are the wishes of the board?
Move denial.
So you're supporting staff's recommendation? Okay.
I would second with a comment.
Okay. Motion by Commissioner Long and a second by Commissioner Welch.
I think Mr. Pressman had a Herculean task here, but this is just not the right place. And I don't know if you caught it, Madam Chair, but the young lady with the children was on our youth advisory committee.
I love it, yeah.
And I think she said that she does abut this property and the kid's bedroom faces out. And I just think you have an expectation when you have a home that the land use and the zoning is not going to be changed radically. Despite how nice the newer units might be, I think that neighborhood had an expectation, and I think that's why you saw unanimous ruling from the LPA. So I support the motion.
Okay. Commissioner Akers?
Yeah, well, I too wanted to commend the proponent's presentation. This is a tough thing. You feel like you have a piece of property, you ought to be able to do something with it, and I guess selling it for a reasonable price would be one option. Selling it to a developer to build 5 or 6 homes, I'm sure, probably 6 or 7, but just say 5 or 6 homes is certainly an option. People who live there for years and have an expectation that it will be residential, that it has been residential. Why neighbors that aren't abutting it feel compelled to come forward, I call it, commercial creep, away from the zoned, away from a node of commercial activity. Then you start to creep down the road, and then it just keeps creeping. So I think there is a concern by neighbors, and legitimately so, about that activity. This node, this particular part of the node, is already a big piece compared to the other nodes, if you will, on the other corners of the intersection. They chose to live next to a residential neighborhood. The gentleman who bought the property chose it as a residential neighborhood and has options to sell or use it as a residential neighborhood. And I do think you just have to take into account the overall vision of that corridor. And I see a lot of residences. I took the opportunity today, just for the record, to drive over there and drive through the area, drive through the community, just to get a feel for what we're talking about tonight. And I certainly, again, I'm a property rights person, and I think you have the right to do something with your property, that you bought it and have the expectations of moving it as such, and no more than that. Now, you're asking for more than that, and I don't think it's appropriate. I don't think this property is appropriate for that use, so I will support the motion to deny.
All right, any other comments?
Yeah, I've got some comments. And thank you, Madam Chair, and I don't want to dwell on it, but I do agree that the owner did buy the property, and it's been residential since the 70s, and I understand that. But I just want to reiterate it again, that the concerns about that particular business, being in that business for a whole lot of years, we don't have crime, and even the traffic study says 9 more cars, so I just feel compelled to make the statement that, I can't even, I'm trying to sell mine, and the residents that are nearby are prohibiting me from selling it, even though it's commercial, because they want to keep the quiet commercial business that's there, and they don't want an ALF, and they don't want assisted living, and they don't want even apartments. So I do understand your pain, but this particular business is not the devil in which you were making it out to be, I promise. But I do agree that you're in residential, not in commercial, and you always have been. And I do agree with that. And I will support the local planning association because I think the owner does have some more options. But I'll tell you, when he says the devil that you know, looking at the pictures of this house and knowing the issues that I have on the beaches with Airbnb and what could happen in a house like that could be your biggest nightmare when you talk about the devil you don't know. I've seen some of the devils you don't know that are in residential homes. And so sometimes you just don't know. But I definitely will be supporting the motion. But there is more to the devil in what you know. So thank you.
Thank you. All right, the voting cards are up. This is a motion to deny. Okay, it's unanimous in denial of the request. Okay, that is thank you all for being here this evening and for sharing your thoughts, and our meeting is adjourned.